anybody have any idea where the remaining collection of souls could be?
We can proceed without Mr. Sheffield. We ran out just right before you first day. We had to go to the lodge. We didn't think we'd go to the lodge house. And the district attorney's office didn't offer to share any portion of the bill with us.
Our micro settlement? That would have worked.
Somebody share a cookie with me, pretty please. Yes. Yeah. A little bit.
We can proceed as well.
My sincere apologies.
Okay, we're back on then. All the defendants present represented by counsel. We were on page 18 with the state.
Thank you, Judge. All right, page 18 at the top we have conjunctive, disjunctive, which actually is the pattern 1.4015. And the state just requested that it be specially tailored, and the court is correct. It is both count 7 and count 9, where we have an and, which of course in legal terms for demurs means it's an or. So what we have is on count 7, did make an assault upon the person of Ahmaud Arbery with a Ford F-150 pickup truck or a Chevy Silverado pickup truck, an object, etc. And then we have count 9, which of course is in violation of the personal liberty of Ahmaud Arbery, unlawfully chase Ahmaud Arbery through the public roadways of the Satilla Shores neighborhood in pickup trucks, and did attempt to confine and detain him without legal authority on Burford. And that is under criminal attempt to commit a felony. So we ask for the conjunctive, disjunctive on both counts 7 and count 9. And then we have the affirmative defense, of course, justification, and then the statute 17460, grounds for arrest, citizen's arrest. Now, when we get to the bottom of page 18, we have right and duty to execute a citizen's arrest. The state objects to this particular charge. This particular charge provided by the McMichael defendants cited to Long versus the state.
Hold on a second. Let me get there.
Sure.
Sorry, grab my roll. Hold on. Which number was it?
This is their request to charge number 3.
Got it. Okay, go ahead.
All right, so what we have here is we have something that says it is not only the right but the duty of a private citizen when a felony is committed to apprehend the felon, and after a felony is committed, any private person may arrest the felon with the same view upon reasonable and probable ground of suspicion of his guilt. That is what they have requested. The problem is, Judge, they have based it on a case that doesn't apply to the facts as we have them here, and that is Long versus the state, 12 Georgia 293. It's from 1852, so Civil War was over 1865. Women got the vote in 1919. So this was in 1852. The thing about this case that's really interesting is that it's kind of the first bribery extortion case. So what we've got is we got a guy, and he's in a wagon, and he's got wagon wheels behind him, and he's going down the road, and these guys jump out and they go, aha, you have the stolen wagon wheels. And he goes, you know, I didn't steal these wagon wheels. They're like, yes, you stole the wagon wheels. We're going to take you to jail. We're going to take you to jail. And he's like, no, go talk to this other dude. He knows that I didn't steal these wagon wheels. And they kept going, we're going to take you to jail. We're going to take you to jail. So after this goes on for some time, they said, except if you wanted to pay us off, maybe, we won't take you to jail. So they go to his house. He goes ahead and pays them off. If the court looks closely at the case, you'll find exactly how he paid them off, which is highly unusual, and I won't mention it here, but it's distasteful. And he pays them off. So they go ahead and they go off, and they tell him, you got to get out of town now. Instead, he goes to the sheriff, and he goes, hey, sheriff, these guys just robbed me by intimidation because they said they were going to throw me in jail, and they were going to arrest me, and they were going to do all these things because I committed this crime of having stolen wagon wheels, which I didn't. But instead, they said, well, pay us off, and we'll go away. You just have to get out of town. So the men who are actually on trial in Long, the guy Long, he's actually one of the men who was extorting money from the victim. And what the court said was, hey, if you're going to go ahead and do a citizen's arrest, defendant Long, it's not only the right, but the duty of a private citizen when a felony is committed to apprehend the felon, not extort the felon. I mean, if you really think they're a felon, you can't go ahead and extort them by going, well, if you don't want us to take you to jail, why don't you pay us off? And what the court held there is that that is intimidation, and it's illegal, and they were convicted. Now, the Long case is cited in 81 cases here in Georgia, but it's always cited for the proposition of intimidation. It's kind of the statement of this is what intimidation is all the way back to 1852, where you cannot basically act in the capacity of a citizen's arrest. I mean, here we are in the middle of Georgia. There is no police force. It's 1852. We're talking wagon wheels. We're talking a guy riding horses with a wagon. So at this point, the court's going, if you're going to arrest somebody, you arrest them. And that's where this dicta comes from. It's not only the right, but the duty of a private citizen when a felony is committed to apprehend the felon. It has nothing to do with, hey, regular citizen, you are at the Shell gas station, and there you are, and you witness a carjacking. You have a duty to go over and arrest the carjacker. Okay? We all know that there's numerous carjackings, murders, everything else that happens in front of a whole bunch of people, and those people all run away. They don't bother to arrest the gun-toting armed robber or the gun-toting carjacker. So this is not actually what the state of the law is. There is no affirmative duty on a citizen who witnesses any sort of crime, a murder, a rape, an armed robbery, an aggravated assault, to affirmatively go and arrest that person. None whatsoever. So, number one, there is no affirmative duty on a private citizen when a felony is committed to apprehend the felon. That is not the state of the law right now. In addition, this is based on a case from 1852 that was saying, once again, hey, if you're going to act as law enforcement, if you're going to go ahead and make an arrest, make the arrest. You don't get to extort money from the person you're threatening to arrest. Now, this defense is probably going to come up here and go, well, it was cited in Johnson versus Jackson in 1976. And it was. But that case actually was a law enforcement officer who's pulling up in his driveway. And there's a strange car there, and there's two strange guys, and they're coming from his garage. Turns out they're brothers. So he gets out of his car, you know, it's dark out. He's like, hey, what are you guys doing? What's going on here? In traditional fashion, they both answer at the same time with completely different answers. So he's very suspicious because, hey, they've come in from his garage. He doesn't know them. They're here. He doesn't know what's going on. They immediately bolt and try and run him over with their car. So they go and they run him over, or try to run him over with the car. He, of course, home from work, he's a law enforcement officer, pulls out his gun and goes ahead and starts shooting at him. What happens? He shoots one of them in the back of the head through the rear of the car. This particular case is actually a civil case. All right? At issue here is the relation between landowner and burglar or felon, the owner's right and authority to arrest the felon, and the allowable force and effectuation thereof, and the duty owed by a landowner to one who is there for the purpose of committing a felony, all of which is for the determination of the jury. But once again, remember, this is a civil case, This is a man who is at his own personal property and sees them going into the garage and starts questioning them. They then try and run him over with the car, and then he shoots and kills one of them. He was sued by the parents of the young man who was shot in the back of the head fleeing. So while trying to identify the two strange men unlawfully on his property, Jackson was violently assaulted when Johnson swerved his automobile to strike him, causing Jackson to fear for his life and also making it impossible for him to read or take down the license tag number of Johnson's car, of course, as he went away. So this is the most recent case that actually is sort of on point. And they go ahead and they then cite to, I'll find exactly where they cite to it. They cite to Long over here about it is not only the right but the duty of a private citizen when a felony is committed to apprehend the felon. And they go on to cite that. In addition, they then cite to another 1890 case and then a 1926 case that a private man has quite as much power to arrest a fugitive felon where the emergency calls for immediate action as a public officer, and while doing so is equally under the protection of the law. So that case really is not similar to this case at all. I think that this is a misstatement of the law as it applies to the facts of this case, and the support for it, these two cases that they cite, one of being a civil case from 1976 with the U.S. Marshal in his driveway, really doesn't have the same facts that we've got where it's a duty of a private citizen. So my fear, of course, is that charging them on this law, the defense is going to get up here and go, well, he had no choice, he had to do it, it's his duty to do it. It's not only the right but the duty of a private citizen, making it seem as if there's consequences to him if he doesn't do it. There are no consequences to him if he stands in his driveway and does absolutely nothing. But this charge actually makes it seem, and they're probably going to argue, that there was some sort of duty, therefore some sort of consequence to him, which is not the law. We ask that this charge not be given.
All right, that was a McMichael's request.
Allow me to report. If I may say, speak from a seated position, I have notes and computer and all that. Well, the Long case is, in fact, the first case in Georgia's history that cites the citizen's arrest statute. And it cites it in the exact same wording that it existed in our state up until 2020 when it was modified and changed very much. The fact that it's an 1852 case shouldn't count against it. I think count one is murder, which goes back to the code of Ahmaud Arbery about 3,500 years ago. So the age of a law makes no difference to it. And I find it of interest and like to add this for the court in considering this statute, that the Georgia Supreme Court didn't come into existence until 1846. So we were only 6 years into the existence of the Supreme Court when Long was decided. And Long was, in fact, a citizen's arrest case. That's the defense that was raised. And it was very well analyzed in that old case. And I also would like to point out, too, for the court, that many people confuse the citizen's arrest law by calling it a Civil War era statute, or sometimes we've heard it referred to as a slave catching statute, both of which are false. The reason it's called Civil War era statute is because Georgia codified its code in 1863, as we all know. That was the first code of Georgia. And the statute that the code included on citizen's arrest in 1863 had been in existence since the year 1215 in the statutes of Winchester in England. It was then English common law, was brought to the colonies. It existed in its present form in the colony of Georgia, and then when we became a state, it was in our laws, as all of our laws were then, scattered in pamphlets and cases and statutes, until we got it all collected, the first state in the nation to collect all their laws in one place and call them the official code of Georgia. And that was 1863. Now, Jumping forward then to 1976, the case Ms. Dunikowski just mentioned, which is Johnson v. Jackson, 230 Southeast 2nd, 756, or 140 Georgia Appeals 252. It's a 1976 case. I'd like to read a paragraph from it. It cites the statute as it existed in 1976 in the exact same words it existed in 1852, as well as it existed in 1730 when Georgia became a colony, and 1787 when we became a state. Same wording. And then that case, Johnson v. Jackson, goes on to say this: it is not only the right but the duty of a private citizen when a felony is committed to apprehend the felon, and after a felony is committed, any private person may arrest the felon with the same view upon reasonable and probable ground of suspicion of his guilt. This 1976 case is citing Long v. State from 1852. Then it goes on to cite, a private man has quite as much power to arrest a fugitive felon where the emergency calls for immediate action as a public officer, and while so doing is equally under the protection of the law, citing Croom v. State, an 1890 case. And then it goes on, and he apparently has the right to arrest under certain circumstances in order to prevent a felony from being committed, which felony has not yet been attempted, citing a 1959 case. And after citing those cases without overruling any of them, of course this is the Court of Appeals, but it didn't go up to the Supreme Court, none of those rules have been overruled. They go on to say of Jackson in this case from 1976, this is the U.S. Marshal who was off duty, came home, found the two brothers sitting in an idling car in his driveway with his garage door partly open. Based on those circumstances, he wondered, what are these two guys up to? So we inquired of them, why are you sitting in my driveway in an idling car and I can see my garage door open? And that's when, after one of them gave him his wallet, they drove off and he fired 2 shots at them and killed one of them. And so this was a civil case for wrongful death. And the court says Jackson, the off-duty U.S. Marshal, attempted to make a citizen's arrest. And this is right after what I just read, the paragraph I just read. Based upon what he saw prior to the assault and flight of the deceased, which resulted in the fatal shooting. What are reasonable and probable grounds for suspicion is for the determination of the jury, as is whether the circumstantial evidence was sufficient to establish the commission of a burglary. That's the crime he suspected, was burglary. The questions of whether the force used was reasonable or whether the killing was under the circumstances necessary, because he raised a self-defense claim, because the car hit him and knocked him over. And so the analysis is very similar to here. It converted from an attempted citizen's arrest into self-defense when the car nearly ran him over. And so they were saying under either situation, those circumstances likewise are to be submitted to the jury. So while Long is an old case with a very convoluted and fascinating story behind it and an interesting history, it's still being cited all the way up into the 1970s and beyond. And it's never been overruled. And it basically just states what ultimately became the code of Georgia anyway, and the statute that we're operating under. But the language that we've taken from the case is still good law, and we defend it and ask that the court give it to this jury.
All right, the request number 3, which adds the right and duty language, the court finds actually the statutory language, which is right above 17460, covers citizens' arrest. As to these cases, they're addressing circumstances that were before the court at this time. I think the statute is, it's either the original statement, depending on how you look at the history of it, or restatement, but it is an accurate reflection of the law. The added language about the duty of a private citizen, the court's not going to charge on. So again, we're just going to stick with the language of 17460, which is that charge above. It's of course not going to, but and the exception to the objection to the charge is noted.
You know, while we're talking about the citizen arrest statute, Your Honor, I have a continuing disagreement, I think, with co-counsel on the statute. The first sentence of the statute covers any offense. The second sentence covers felonies. So effectively, the first sentence covers misdemeanors. And there is no misdemeanor here to discuss. Either Mr. Arbery committed a burglary on February 11th, or he committed a burglary or committed a burglary on February 23rd, or he committed no crime at all. If the felony that you're intending to commit if the crime that you're intending to commit when you trespass is a theft, it is a burglary. So there is no factual basis in this case for charging the jury about arresting someone on a misdemeanor, which under Georgia law have to be within the presence or the immediate knowledge of the person making the arrest. But there is no misdemeanor that would justify the actions of the McMichaels on the day in question, or Mr. Bryan. So it is inappropriate to charge that first sentence of the statute because it's not supported by the facts of the case. And that leads us to the problem that we have on the next page with making an arrest contemporaneously. Now, I've already submitted argument to this court and a charge a long time ago. And I know the court's aware of it because the court, I think, borrowed some of it in what the court has put together. But there is absolutely not a single case in the state of Georgia that says that a felony can only be arrested immediately. That time, that proximity in time, there is not a single case in Georgia that says that in a felony case. So why are we including the only reason we're including that language is because it ties to the first sentence in the charge on the previous page that doesn't apply to this case. There's no reason to be charging the jury about arresting someone for an offense in his presence or immediate knowledge. The second sentence, felonies, is what applies, and therefore there's no reason to be giving this charge requiring a temporal proximity between the observation or the development of the probable cause and the arrest. I'm like Ms. Donikowski. I mean, to me, this is a huge deal in this case, and it's unsupported.
Your Honor, if I may, I think Mr. Goff has moved ahead to another jury instruction. So if we're
let's keep on track.
Yes, if we're
trying to do
on
this
that.
in a linear fashion so we don't bounce all over.
Oh,
Let's when we get there.
okay.
And we're almost there.
Oh, I thought Mr. Goff was actually talking about 17460.
I was simply pointing out the connection between the one I started with and the one behind it. But technically, we're talking about 17460, 2/3 down page 18.
Okay.
That
In
was-
that context, then, Norm.
above the right and duty to execute, but that we would like to be heard. We have a very different opinion of that.
So, regarding 17460, to address Mr. Goff's concerns, first off, Mrs. Hogue is absolutely correct. Frank Hogue, Mr. Hogue, got up an opening statement and said, totally agreed with this statute. That's what he actually talked about in opening, that a private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. It does not distinguish between felony and misdemeanor. So the first assertion by Mr. Goff is, well, this applies obviously to misdemeanors. That's not at all. It says may arrest an offender if the offense is committed in his presence or within his immediate knowledge. It then says if the offense is a felony, and Mr. Hogue actually, I believe in opening, said, yeah, that offense has to be committed in the person's presence, and the offender is escaping. So this sentence has two things that have to happen. So it can't be a misdemeanor and he's escaping. It has to be a felony and he's escaping or attempting to escape. A private person may arrest him upon reasonable and probable grounds of suspicion. So the state asks that you put this charge in and do not take out the very first line, because the assertion that Mr. Arbery committed no crime or committed only a burglary, that's not for him to decide. That's for the jury to decide if he committed any crime at all. And they could decide that it was a whole host of things, and not necessarily a felony. So on that issue, that's what our position is, that the statute be read.
Yes, a brief response. I think Ms. Benikowski misheard or mischaracterized what I said in opening, but that aside, we do want the whole statute read. But here's the important distinction between sentence 1 and sentence 2. And I've read every single case in Georgia on citizens arrest, and this is clearly the case. Sentence 1 applies to both misdemeanors and felonies, but says those must have occurred in the presence or within the immediate knowledge of the citizen conducting the arrest. And then there's plenty of cases, usually in the context of store owners and store managers, talking about what constitutes presence and immediate knowledge, applicable to both misdemeanors and felonies. I have not mentioned that sentence in opening statement. Don't think that we're going to argue that on the facts of this case. The second sentence, however, concerns only felonies, and it concerns the reasonable and probable grounds of suspicion for the citizen to think that the felon is escaping or attempting to escape from the commission of a previously committed felony. So it does not have to be contemporaneous as it does in sentence 1. All of the sentence 1 cases do require a contemporaneous event near in time to the pursuit by the citizen to apprehend the person, either in the act itself while putting the item in his pocket, or after he's left the store and the alarm's gone off and they chase him to his parking lot. Plenty of cases like that. But the second sentence does not require contemporaneity with the felony. It only requires a reasonable and probable grounds to suspect that the fleeing person that you're now pursuing is fleeing from capture for a previously committed felony. In our case, the felony that we can reasonably suspect has possibly occurred 3 months prior to the fleeing that we witnessed, not that day. We don't have to believe that Ahmaud Arbery committed a felony on February 23rd, 2020 to come under the second sentence of the citizen's arrest statute. It would be similar to, say, for example, you have encountered a burglar in your home. You got him on camera. You were home and saw him. You have a clear identification of him. And then 2 weeks later, you're filling your car with gas at the gas station, and there he is. You see him, and you recognize him. He recognizes you. And you say, hey, you're the guy that was in my house. And he turns and runs. Second sentence of the now repealed statute would authorize that citizen to pursue the fleeing felon, of whom he has reasonable and probable grounds to suspect has committed a felony 2 weeks prior in my house when I saw him there committing burglary or whatever else he may have been committing. So I think it's confused and it's incorrect and it's not the law to state that both sentences require presence and immediate knowledge and contemporaneity with the crime. That is not the law. That is not the case. All of this is to say we want Unlike Mr. Goff, we want the whole statute read just as it was, just as it is in Fort, or was in Fort 17460.
With all due respect, Your Honor, I would like a 5-minute recess so we can confer, because I'm sure that this argument makes perfect sense. I just don't understand it. And this is the ball game here. If there's a mistake in this charge, case closed. The way this is reading to me, it's a directed verdict of guilt. And I don't mean any disrespect by that to anybody. But this is huge. And I think a 5-minute recess, so at least we can all be on the same page. If we can be, would be productive here.
I think we could have the discussion right here. We're just having a charge come.
It's a charge code. So, no, because what is in the charge is the statute. So, I'm not going to break the statute up. Sounds like there's an interesting discussion that is to be had over this theory on what the statute means. But as far as the charge is concerned, it's the statute. That is the language of the statute, now repealed, that the court intends to charge upon.
What is the factual basis? Lots of statutes have multiple parts. We don't charge the parts that don't apply. What evidence does the state have to support an arrest for anything other than a felony and the individual fleeing from it? What is the factual basis for any other theory here? What could I'll put it to you differently, Your Honor. If Mr. Arbery had survived and was on trial for burglary, he would not be entitled to a charge on criminal trespass. So why would be submitting to the jury in this case a criminal trespass charge that's unsupported factually by the evidence? Now,
If I may answer that?
Yep.
Your Honor, the defense in this case is an affirmative defense, which is self-defense. Problem is, there's 3 things you can't do and claim self-defense, and these defendants, in the state's opinion, did all 3 of them. So they then need to go, well, how can we justify the 4 underlying felonies? Well, we'll go ahead and say we were doing a citizen's arrest. It's an affirmative defense. It's the defense saying, hey, we were doing a citizen's arrest. The state, of course, is the one who has to rebut that beyond a reasonable doubt. So putting the burden on the state to say and explain what crime it was that Mr. Arbery's committing. The state's position is Mr. Arbery didn't commit any crime whatsoever, and the defendant certainly didn't know about any crime he committed that day. Running down the street on February 23rd, 2020 is not escaping from the felony, which we don't even know when it took place, in October or November, maybe in Satilla Shores, maybe in Douglas, maybe in a parking lot in the middle of the night in 2019. So that's for them to argue. Mr. Hogue put it out there. That's what they're going to argue. So at this point, the statute should stay as it is because it's their statute. It's what they're going to affirmatively tell the jury, and that's what they're going to rely on. The state has to overcome it, and the state will. They knew nothing about any crime he had committed that day. So we ask that this be to stay in exactly like it is.
And Your Honor, the evidence that came into trial with the video on February 11 on its own is, in the video that the state played, is the phrase, I'm sorry.
This is all argument. And I'm not meaning, I'm trying to stop the whole
I
circular.
you would stop. You're going to charge the whole.
Yeah, I'm charging the statute. This is all argument. And the fact that the argument exists means that there's probably facts in the case to argue what we have here. It's the statute.
Misunderstood.
Thank you, Judge.
I'm sorry. I didn't want to. I was the one who started the discussion, and I'm not questioning the court's ruling. But I do think it would be helpful, since the state is saying that there was no misdemeanor committed. Maybe somebody could explain to me, so I can understand what we're doing here on the defense side, what the defense contention of what misdemeanor we're talking about, because I don't understand it. And somebody has to have a factual basis for the charge. It doesn't matter whether it's an affirmative defense or not. There still has to be a factual basis to talk to the jury about any misdemeanors that it is contended that Mr. Arbery committed, because it gets into the temporal requirement that the state is trying to graft onto this, which I guess we'll be taking up next. So again, if there's no factual basis for it, then why do we even get into the other discussion?
The objection's noted. Court indicated we're going to charge him.
Thank you, Judge. So next, terms are synonymous. The court's already charged that in its pre-charge. So that's done.
Except for the additional sentence that the state has added here. The final sentence, a private person may not act on hearsay or information furnished him by other persons, which is directly contrary to the law.
And when you're ready, I can respond to that, Your Honor.
So
If the state's done arguing for that charge, which is, I forget.
From the state?
yes, thank you, Judge.
Charge 54.
So basically, Judge, we're going to go ahead and cite to the cases that we had in our charge 54. And all of them, for instance, Forehand versus the State, 130 Georgia Appeals 801, 1974 case, yes, holding that in his presence and the words within his immediate knowledge are synonymous. To justify the arrest without a warrant, the officer need not see the act which constitutes the crime take place if by any of his senses he has personal knowledge of its commission. What the officer sees must be what he sees before the arrest and not afterward. Young versus the State, 238 Georgia 548, 1977. While the actual shoplifting was not done in the sight of the manager, appellant's admission, together with other evidence of the shoplifting known by the manager at the store, were sufficient to bring the offense within the immediate knowledge of the manager. I mean, the person confessed to it, and then authorized him to arrest appellant without a warrant. The terms in the presence of and within his immediate knowledge have been held to be synonymous. And then we've got Winn-Dixie Stores versus Nichols. This is a 1992 case. We agree with appellant that as a matter of law, it owed appellee no duty to confront or arrest the couple she was accusing of stealing her wallet. The alleged crime was not committed in the presence or within the immediate knowledge of Arrowwood or any other employee of appellant, Winn-Dixie Stores, and thus Arrowwood and other employees of appellant were not legally authorized to arrest the alleged criminals. So, Judge, here we've got somebody, a patron of Winn-Dixie, going up to store security and going, hey, that woman over there took my wallet. Well, they held here, hey, store security is not obligated to go arrest her based on her accusation because it wasn't done within the store security's immediate knowledge or presence. They actually cite to 17460. Indeed, the only person who could have effectuated a citizen's arrest was the appellee herself, because she was the only person who, by the exercise of her senses, had knowledge of the crime's commission. They then cite to Johnson v. Jackson, basically stating, and that's the U.S. Marshal case in the driveway, basically stating the only person in Winn-Dixie that was able to go ahead and effectuate this is the person who saw it, who knew about it, who witnessed it. Not even reporting it to store security allowed store security to go arrest this woman who allegedly had taken the wallet. So in this particular case, that is why we said a private person may not act on hearsay or information furnished him by other persons, because we've got a 1992 case right on point. The court then went on here to say nothing in OCGA 51760, which is the arrest statute, suggests that a merchant is authorized to detain or arrest persons accused by business patrons of committing crimes against the patrons, since that statute expressly involves only the limited right of a merchant to detain or arrest a person reasonably believed to have committed the offense of shoplifting under 16.814. So, Judge, I understand what the defense is going to ask, because they cited to a number of cases, and they actually asked for a charge. Let's see if I can find it. Well, maybe they didn't ask for a charge, but I did some legal research. And what I found, Judge, were a number of cases that talk about police communication. And we've got Goodman versus the state, 255 Georgia 226, 1985 case. We've got Gregory, Gregoire versus the state, 285 Georgia Appeals, 111, 2007 case.
I'm going to redirect you. You are actually looking at my request to charge number 4. It was just
Excellent.
titled probable cause.
Excellent. I thought it was in there.
Yeah.
I just skipped right
That's
over it.
fine.
So there we go. All these cases I looked up were under request to charge number 4, probable cause by the McMichaels. And each and every one of these cases is police communication, not citizen communication. And we know what police have. They have radios. Okay, so they're able to communicate in absolute real time with each other about things like this. So in Ferguson, 1996, we've got malice murder and felony murder, armed robbery. Basically, she maintains that she was unlawfully seized and that her arrest was illegal because it was without probable cause. And they talk about probable cause. An officer may make a brief investigative stop of a vehicle if it is justified by specific articulable facts sufficient to give rise to a reasonable person of criminal conduct. Okay? And they're talking about an investigative stop at that point in time, which does not apply to citizen's arrest. There is no citizen's detention, citizen's investigative stop. It's an arrest. And they talk about the police, they had probable cause which can rest upon the collective knowledge of the police when there is some degree of communication between them instead of the knowledge of the specific arresting officer. So most of these cases, in fact all of them cited by the defense, talk about the collective knowledge of the police. Well, the police are able to communicate because they've got radios, and they're able to communicate to each other that way. And we got 96, we got 2007, we got 85, we've got 2007. So to say, well, that somehow applies in this case, that, oh, a private person can act on hearsay or information furnished by other persons when the statute specifically says within their immediate knowledge, and we actually have a 1992 case right on point. You can't make an arrest based on the lady in the store coming up going, she stole my wallet. So we ask that a private person may not act on hearsay or information furnished him by other persons. We ask that that part of the charge be given.
May I respond, Your Honor? We're objecting to the last sentence of this request only. A private person may not act on hearsay or information furnished him by other persons. Again, I emphasize there is a distinction between sentence 1, citizen's arrest, and sentence 2, citizen's arrest. Sentence 1, citizen's arrest cases are the ones the state is citing to the court right now, because it's required that the arrestor, the citizen who's conducting the arrest, has seen the crime, misdemeanor or felony, or has immediate knowledge of it. And there are cases that say those two terms are synonymous, even though they stretch it a little bit. And the best case to illustrate that is Murney versus the state, Merneigh. Again, that's another shoplifting case. It's a misdemeanor. And the store manager in Murney did not see the shoplifting happen. The food manager called the store manager in his office and said, hey, this guy just left the store with stolen stuff. The store manager heard the door alarm go off, came downstairs, saw Murney in the parking lot, and chased him along with another employee. So Murney defended himself at trial after he got caught by the police, not by the store manager. He pulled a knife on the store manager and they gave up the chase. But the police caught the guy and then they charged him. And then he said in his defense, they were not conducting a lawful citizen's arrest of me when they chased me in the parking lot. And the case holds that, and their argument was because the store manager didn't see me steal anything. It's all sentence 1. And the court said, no, he had immediate knowledge of it because he got told by another employee that Murney had shoplifted something. and then he heard with his own ears and saw with his own eyes circumstances that supported what he'd been told, and therefore they said immediate knowledge is synonymous within his presence. First sentence citizen's arrest case really doesn't apply here. And all the other cases but one, and it's one I want to point out, and that's important here in this saying that this sentence doesn't apply, all the other cases the state is citing are basically sentence one shoplifting type cases, except for one. And it's Denon versus the state at 173 Georgia Appeals 191 1984 case. The state cites that, but just cites it, doesn't give any summary of it. I would like to give it now because it supports our position that that last sentence does not apply, is not the law, and shouldn't be included in the charge to our jury. And here's the basic, as thinned down as I can make it, Judge, of what happened in Denon. And this is critical to our case, so allow me to tell this story. Dr. Denon was at home with his wife. He owned a shopping center. In that shopping center, one of his sons owned a restaurant, and his other son, their names were Tom and Jim, was remodeling another storefront that he was going to open with his partner, Sam. And so while they were remodeling this place, they didn't have a phone, but Tom, the restaurant owner's son, did have a phone in his restaurant. And the two renovators saw this guy outside of the store in the parking lot attacking a young woman. She was running towards them. They came out. They took her to protect her from Wendell, the guy attacking her. And then one of the two renovators, Sam, tackled Wendell and took him to the ground and was holding him on the ground while they were trying to get to a phone to call the police to come get Wendell. Well, Wendell took off. But he came back in his car, and when he arrived, they said, "You've made a mistake. You shouldn't have come back." And that's when they held him on the ground, and all these kids from across the street saw what was happening. They came over, they knew Wendell, and when the police arrived, Sam has Wendell on the ground, and they tell the police that Sam is attacking Wendell. The police officer walks up, sees Sam holding Wendell on the ground. Again, he's protecting this young woman from Wendell. The police officer takes out a nightstick and cracks Sam on the head a couple of times with it, arrests him, and puts him in the back of a patrol car. Now, Dr. Denon, who owns the shopping center, didn't see any of that. He was at home. The other brother called him and said, "Dad, you need to come down here. They just arrested Sam and his other son, who got vehement and was cursing at the police officer, telling him, 'You arrested the wrong guy. Wendell's the bad guy here, not Sam. You believed all these kids. They're not telling you the truth.'" Dr. Denon arrives. He sees Sam in the back of the patrol car. He has blood on his head. And then his other son tells him the story I just told the court. And so Dr. Denon says to the officer, "You need to let him go. You've arrested the wrong person. And you've assaulted him, a felony." And the officer tells Dr. Denon basically to mind his own business, and he turns to leave. And he's now, under the citizen's arrest statute, sentenced to fleeing from capture of a felony. Dr. Denon puts his hands on him to hold him, says, "I'm making a citizen's arrest," says that to the police officer. Well, Dr. Denon ends up pinned up against the car by a couple of police officers, punched a few times, and then he gets taken to jail. He goes to trial. That's why the case is reported, because Dr. Denon got to trial, And he said, Judge, I want a citizen's arrest statute. Sentence 2 is my defense, my only defense. Trial court refused to give that charge. Dr. Denon was convicted. And the court wrote, when they reversed his conviction, it is the law of this state that where there is only one defense on which a party relies, failure to instruct the jury as to the evidence supporting this defense with sufficient clarity and specificity that the jury will not only be required to pass upon it, but do so intelligently, in practicality directs a verdict against the defendant. In that the effect of the failure to charge is to withdraw and deny the defense, and to that extent prejudices a defendant's right to a fair and impartial trial. They go on to say only slight evidence requires the giving of a charge, even though other evidence tends to show the non-existence of the fact. It is not so much whether Dr. Denon made an informed and correct decision that a felony or a misdemeanor was involved, but whether his state of mind was that he intended to make an arrest of an escaping offender, or whether he, in anger or otherwise, intended to injure Officer Wagner. We conclude that the refusal by the trial court to present to the jury the sole defense offered by Dr. Denon was prejudicially erroneous and requires a reversal of his conviction. So it's a good case to cite, but not for the proposition that the state has cited it. It says nothing about a private person may not act on hearsay. Dr. Denon did act on hearsay. He got a phone call while he was at home, probably in his pajamas and slippers watching TV. He came down there and all this other stuff ensued, and the appellate court says you should have told the jury about citizen's arrest. You denied the man a fair trial. That applies here. That sentence does not apply to our case and it should be omitted. I wouldn't mind if that entire charge 54 was omitted because it all applies to sentence 1. We're not going to argue sentence 1, even though we're happy that the court's going to give the entire statute. It's only 2 sentences long anyway. But
well, we don't need to go there. I've already charged them.
But this charge, this request, charge 54, is not the statute. It's citing the statute in the name of the charge, but it's citing partly correctly, but partly incorrectly, what sentence 1 means.
I won't try and revisit what the court's already ruled on. But I have a real problem with it. I have a problem with the whole section. But I have a problem like Mr. Hogue does with this last sentence. There are cases, I'm pretty sure in Georgia, and I know in other jurisdictions, which apply this same language, this immediate knowledge and presence. That's pretty common across the country in citizen arrest statutes, Your Honor. And in the cases involving law enforcement officers acting under the citizen arrest statute, which is a substantial body of the entire citizen arrest case law, in those cases, police officers making citizens arrests have been allowed to rely on information provided by other individuals. And the best explanation I can give for the distinction is, Your Honor, when we talk about within the immediate knowledge, what we're talking about is the present knowledge. Not knowledge acquired in the moment, but knowledge acquired prior to or at the time. In other words, that after acquired knowledge from other people would be inadmissible, but any information that was possessed at or before the time frame is appropriate, even if it's coming from third parties. And this is exactly that case, where the McMichael defendants, as I understand it, I'm not trying to put words in anybody's mouth, but are contending that they not only saw videos, but received information from other people, and they relied on the information previously acquired on February 23rd. And that is a distinction. in terms of arresting someone and then trying to come up with an after-the-fact rationalization, if in fact there is knowledge that has come from a third party prior to or at that time, then that is knowledge within their immediate knowledge. And the state is pushing and asking for too much in this last sentence. And we would ask the court, joining the McMichael defendants, to strike the last sentence of the terms are anonymous state charge number 54 that it currently appears at the top of page 19 of the court's charge.
Okay. So, I guess harkening back to some of the discussion about citizens arrest, it is interesting that a lot of the cases do involve shopkeepers and store clerks and subsequent arrests. And I think the way to solve what we have, I don't agree. Well, first of all, given what the courts, the appellate courts, have sort of parsed through in order to get to some reasonable explanation for what the authority is, what you can sort of take from those cases is this hypothetical store manager can't just walk in and assume somebody is running because he has been told, oh, that person might have stolen something. They can't run out and do that. They would need additional information. And some of it is the store videos, for example, that are referenced in some of the cases, or the alarms going off. So there's more to it. So I'm going to keep that sentence, but I'm just adding the word alone at the end of the sentence. So it's a private person may not act on hearsay or information furnished to him by other persons alone. In other words, there has to be more, which I do think starts fitting into the facts of this case, which, as I understand from Travis McMichael's testimony, was there was more to his explanation than simply hearsay as to why he acted. And so I'm going to add that. I'm going to keep the sentence, but add the words so that it's understood that there needs to be more than just hearsay. What that is and what the actions were, or what the actions were based upon, has already been explained to the panel. So that's how I intend to solve that.
Thank you, Judge. The state agrees.
Thanks.
So,
I assume there's an exception to that.
There is. My concern is even adding the word alone. So I guess the sentence would read: a private person may not act on hearsay or information furnished him by other persons alone. And I'm thinking now for Greg McMichael specifically, what that may do to our defense. You've alluded to other information Travis McMichael had, since he encountered Ahmaud Arbery himself personally on the night of February the 11th. For Greg McMichael, he never encountered him personally at any time other than on February the 23rd.
There's testimony about him going out to the house and taking other actions. There's other evidence in this case. What this is simply saying is you can't just do it purely on hearsay. Just because you were told to go chase somebody, don't go chase somebody. Or told that somebody did something, don't go chase somebody.
Hearsay or information furnished by other persons alone. I mean, information furnished by other persons, would that not be synonymous? Video.
I mean, Larry English showing him the videos, or him seeing the videos. It
seems to gut at all the sources of information that we did acquire. I mean, some of it you could say is hearsay. If a person tells Greg McMichael, yeah, I think this, or I saw that, or this is what I know, you could say that's hearsay. If it also says information furnished him by other persons, now we're talking about videos shown him by Rash, still shots shown him by Rash, Diego Perez showing him videos. That's information furnished by other persons alone, and that sentence, therefore, I fear a jury could say, well, that guts Greg McMichael, because that's all he's got. He was never at the house and ran into Ahmaud Arbery himself personally. I'm afraid it would direct a verdict of guilt for our client.
No, I'm trying to think. Again, I'm going to these shopkeeper cases in my mind and thinking, what is the type of information that we've been talking about? Because that's really where this has been parsed, I think, more than any other place. And that is the court justifying how you can get effectively a third party to what was happening, that authority to go ahead and act. And that, in those cases, those individuals are looking at video and looking at other things provided to them by third parties. Now that's in their capacity in the store, but I'm not sure that that's necessarily the...
If you could-
Speak up a bit.
Yeah, no, I'm thinking it through out loud, again, using the
I just want to hear your thoughts. I can't hear it.
sometimes I need to keep my thoughts to myself.
No, it's helpful for this process.
Yeah. No, I understand what's being said. I think then the alone goes after the hearsay, and the rest of the sentence is taken out based on what I'm thinking through here. What I'm inclined to do is that sentence is going to be a private person may not act on hearsay alone, because I think that then covers the idea that we're talking about here in the evidence presented in this case.
Could I inquire, Your Honor? In terms of saying to the jury, a person can't act on hearsay alone. Hearsay, as we've been discussing it here, is any statement made outside of court, now offered inside of court for the truth without that person. Right? But what the court seems to be saying is we're talking about a different kind of hearsay. Meaning, if Travis talks to Rash, and Rash says, there's been burglaries in this house, or break-ins, or trespassing, or whatever. Or is the court saying, and the court would sanction the state arguing to the jury, the court's going to charge you, Travis can't rely on a statement given to him by Rash, because that's hearsay.
Well,
Or Travis can't rely on his mother, because that's hearsay. Is that the court's going to allow the state to make those arguments? Which leaves then what? Unless Travis was in the house at the time the stuff was taken and he saw it himself happen, then he's got no evidence about a burglary because he wasn't in the house at the time it happened?
No, that's not.
That's what I'm concerned about.
No, and I understand that. That's not what I understand. So hearsay,
not.
so
That's a
hearsay alone would be, for example, if there were no videos, they weren't looking at things. If someone just came up and said, "Oh, I saw a video," and he acted upon it, that's hearsay. But if there's discussion
like
about this video and
hearsay.
he's seen it, then that's the circumstances that we get in some of these cases that are out there, where, yeah, the individual's being told what was seen on the video. They looked at the video and acted. So I think there's a subtlety there. I understand where you're going with it. I don't think we're using a legal definition necessarily of hearsay. This fits, in my mind, to the facts of the case, given the case law that's out there. Because what we're talking about here is there's no argument, I think, from the state that Matt Albenzi was out on the street and pointed down the street, and simply based on him yelling or pointing down the street or whatever it is, that's what the defendants acted upon. There was more information there that the defense wants to talk about. If it was just Albenzi pointing down the street or making some comment, I'm just talking hypothetically, that's what this is trying to avoid. That's what this language tries to avoid, because I think that more tailors itself to the cases that are out there.
Is hearsay the proper word?
Well, that's the word that was used in the cases.
May I just jump in for a little bit on the point I think I'm hearing Mr. Sheffield make? It's an excellent one, because there are two different uses of hearsay being
How about
used
this?
here.
Unsupported statements of others alone. That's probably what we're talking about here.
And Judge, just to correct the record, Mr. Sheffield just said the state's nodding its head. The state was not nodding its head in agreement with what Mr. Sheffield was saying. The state was nodding its head in understanding of in my mind, I was thinking, okay, I understand where the defense is going to go in their closing argument. So I don't want it to be on the record that I was nodding my head as if I was in agreement with what Mr. Sheffield was saying as he threw that comment out.
Let's remove the legal term hearsay. It's going to be a private person may not act on the unsupported statements of others alone.
State agrees.
And just to be clear, what we're talking about is the court defining the first sentence of the citizen's arrest statute terms within that.
I'm not prepared to adopt Mr. Hoag's interpretation of the statute and hold that we can get to that.
The only cases that define in his presence and within his immediate knowledge that they are synonymous are the misdemeanor cases, the first sentence cases. There are no second sentence cases that define that. I'm just pointing that out.
You know, I'd say the first and second sentence thing that we're talking about is one reason why I think the citizen's arrest statute was a mess before it got changed. It's the mess that we are living with, but those two sentences are applying to two different scenarios, and it just wasn't ever real clear until you read every single case ever reported on those statutes, and then you see the pattern develop that, as Mr. Rubin just said, all of these presence and immediate knowledge cases are usually misdemeanor shopkeeper cases. And then there's very few cases involving fleeing felons. Very few.
I understand that.
In the few cases previously, felony cases previously cited to the court, the presence and immediate knowledge requirement obviously did not and could not apply.
Let's get past where we are. I understand the defense then takes exception to what is going to be charged, but I'd explain what's going to be charged.
Judge.
When I say the defense, both the McMichaels defendants and the Bryan defendants. Okay.
All right, so next one is must make the arrest contemporaneously, and that is the state's position. The state is basing that on McWilliams versus Interstate Bakeries Incorporated, 439 F. 2nd, 16, a 1971 case, but out of the state of Georgia. And what we have here is we have a guy who goes into the bakeries and does indecent exposure, and a woman sees it. He shows up 4 days later, and she's like, there he is! And they arrest him and detain him for the indecent exposure 4 days beforehand. He then filed suit saying, they falsely imprisoned me because you can't do a citizen's arrest. It's for exigent circumstances. It's for the emergency. It's for the immediacy. If you've got an issue, call the police, have them do the investigation. They take out a warrant. They do what they're supposed to do. And that's basically what Interstate Bakeries said. A private citizen's warrantless arrest must occur immediately after the perpetration of the offense. If the observer fails to make the arrest immediately after the commission of the offense, his power to do so is extinguished, and a subsequent arrest later is illegal. I threw in the word later. That's not actually in the charge. And a subsequent arrest is illegal. And that is actually what we're asking for, because that's what the case law says in McWilliams versus Interstate Bakeries. I believe the defense is going to argue, well, that was a misdemeanor case. It's indecent exposure. So that only applies to the misdemeanor. But here's the problem. If the offense is a felony, meaning the one you just saw is a felony, and the person's escaping, then on probable suspicion, you can go ahead and arrest them. So I'm trying to come up with a really good illustration of a factual basis. Does the court even want me to try and do that right now? Nope? Okay, I won't. I'll just say we would like this state's requested charge number 55, which is must make the arrest contemporaneously.
Your Honor, McWilliams versus Interstate Bakeries is clearly limited to misdemeanor offenses. It is merged with Adams versus Carlisle, which is really the footnote that the state is citing out of McWilliams. And in that instance, the holding is a private person can only arrest for misdemeanor offense when that offense occurs in his presence. And the arrest must occur immediately after the perpetration of the offense. So it's not applicable to the case at bar.
It's a first sentence.
The state disagrees with this first sentence, second sentence distinction that they're making. The first sentence applies to misdemeanors and felonies. The only time the second sentence applies is when someone's escaping. You have to also be escaping. So the first sentence does apply to misdemeanors, and it applies to felonies. And I think Mr. Hogue even stated that and made that very, very clear. So this weird distinction where it only applies to misdemeanors, that is not at all true. You have to, if it's a felony and the person's escaping, then you get to do these other things. Then you can go ahead and chase them down. You can't chase down necessarily someone who's committed a misdemeanor, but you can chase somebody down if they're escaping. So that's really the distinction here between the first sentence and the second sentence. Not that the first sentence is only on misdemeanors. It's misdemeanors and felonies. The second part applies when you're escaping. So I just want that distinction to be made. And here in McWilliams, there was no escaping. And it doesn't matter whether it's a misdemeanor, because the first sentence, immediate presence, if you don't arrest the person who's committed the felony right there and then in front of you, your ability to arrest him later is extinguished. And here's the thing. If the guy's pumping gas, you notice how Mr. Hogue said, well, if he's pumping gas and you would go up and say, hey, you're the guy from the other day, and the guy runs off, all of a sudden he's escaping from something he did 4 days earlier because you confronted him. How many minutes of how many days is he escaping? So it begs that question, and I think we're all going to be arguing that, but we ask that this, which is good law, be given to the jury because it applies to both felonies and misdemeanors, because the second sentence only applies under certain circumstances.
But it is, as my understand though, this entire case is the question of chasing for the purpose of detaining for an arrest. So the question of whether or not it's a misdemeanor or a felony and morphing them all together is just not accurate for the jury and in their assessment. Otherwise, we would not have two sentences in this statute.
If I could just I'm sorry, Kevin.
Sure.
You wouldn't need the second sentence, reasonable and probable grounds of suspicion, if it occurs in your presence or immediate knowledge. You have probable cause if it occurs in your presence. The reason there is the second sentence is because when it's a felony and the person's attempting to escape, there's a lesser burden. It doesn't have to be in your presence or immediate knowledge. You have to have probable cause. And probable cause does not require presence or immediate knowledge. Police officers get warrants with probable cause for events that occurred days earlier, weeks earlier. They get arrest warrants and search warrants under those circumstances. It would render the second sentence superfluous if the definition is as stated by the state.
Your Honor, I don't know. I guess it's the opposite of flattery because, I filed stuff on this a long time ago, and it seems like as Ms. Dunikowski's standing here, she had read it. Your Honor, we're conflating two different issues here. The fleeing felon part, Ms. Dunikowski makes a valid point. You can't go back a year later when someone's sleeping in their house and arrest them as a fleeing felon. There has to be some flight. And just because you have probable cause to believe someone committed a felony doesn't mean you can arrest them. But in this case, if there isn't a fleeing felon in this case, then there never could be. This is the very definition of a fleeing felon. It doesn't have to be fleeing immediately after the crime, but he's fleeing nonetheless. And what Ms. Dunikowski is trying to do here, I may take that back. I should not say what she's trying to do. That's not fair. What her argument is trying to do is conflate the issues on the first and second sentence with whether they're escaping or not. Escape has nothing to do with the first sentence, which respectfully has nothing to do with this case. The escaping part has to do with the felony arrest. Doesn't mean that the felony has to have taken place right then, that the person is escaping then. It means that there has to be an exigent circumstance, which is what the court has already adopted, that part of the language. And the exigent circumstance for the felony arrest is the flight or escape. For example, if Greg McMichael or Travis McMichael and Mr. Arbery were bowling buddies or on the golf team together, and he could look at the video and know who he is. Well, then at that point, he's got to arrest him or not. He can't come back 3 years later. But in a situation where the perpetrator is not identified and is fleeing, that's an exigent circumstance because you can't go back and get him later. You got to get him then. And that's the reason that the McMichael defendants are authorized in this case, and Mr. Bryan to assist them in doing that, if that's what the evidence suggests. There is fleeing here in the sense that if he is allowed to escape, there's no guarantee that he is going to be discovered subsequently any more than he wasn't discovered the first time he went in the house, the second time he went in the English residence, or the third time or the fourth. I mean, that's the personification of flight. And that's why this charge should be allowed. But to go back and say that that's got anything to do with whether it's the first sentence or the second sentence, that's a separate matter. And I think it's confusing for the state to present it that way.
All right. Y'all have argued my brain into mush. So we're going to take a short recess. I'm going to clear my head and figure this out. Thank you.